Yes, Mr. House.
Good morning, my lords. I am here today together with Mr. Cribb on behalf of the appellant, which I'll refer to as the bank, if I may. My learned friend Mr. Hussain, together with Mr. Brown, appears on behalf of the respondent, to whom I'll refer as RCA.
Yes.
This is an appeal from the order of Sir Nigel Teare, sitting as a judge of the High Court, made at an expedited final hearing of this anti-suit claim last September, pursuant to submissions granted by Lord Justice Mail last October. The court has the benefit of what I hope was helpful and full briefing and analysis on the issues, including a reply skeleton argument that we served last December. What I was proposing to do, subject always to judicial guidance or indeed turbulence, was to address you under essentially 5 headings, if I may. First of all, starting with the position in Russia, which will be brief, but we'll cover the legal landscape and the risks it presents to my client, including both generally and in this litigation. Secondly, to go through the bonds. There are 7 of them, and they fall into 2 categories. They're not identical. There are 4 performance bonds, classic guarantees, as it were, and there are 3 advance payment bonds. For present purposes, they are materially identical, but we'll just pick up the differences. And by going through those terms, I endeavour to make all of the textual points that will matter for the court's inquiry as English contract lawyers under Enka to discern the choice of law. That's section 2. Section 3, I'll summarise the position on French law. I don't anticipate there being a great need at this hearing to delve into the reports on French law. Much is common ground, and that which isn't doesn't really matter. I'll summarise that for the court. The 4th heading will then be applicable law. That's the gateway issue, and in a sense the first head or set of grounds of appeal. And then I'll move to forum, 5thly and finally. There will be something to say about the grant of final relief if the court is with us on this jurisdictional appeal. There is a procedural difference between the parties as to what should happen next, as it were. But I would make this observation about that. There is very little left between the parties if this court is with us on this appeal on jurisdiction. That's because all the points which go to forum convenience will have been dealt with by definition in favour of my client, the claimant. And there are at that point only 2 distinct points left which you can get from the trial skeleton of the defendant, RCA, in the court below. Those 2 points are the choice of seat contraindicates the appropriateness of anti-suit relief on the one hand, and a separate point to the effect that they will get a better deal or better outcome before the Russian courts on the sanctions point than they would before a French tribunal. That is all that is left on the discretionary, if I can put it like that, remedial analysis for the anti-suit relief. Both of those are short points. They're both, in my submission, hopeless, and they certainly don't need another day in the commercial court between now and what may well be the crunch date, which is the 14th of February. That is the 4th scheduled hearing in the Russian litigation, following the last hearing on the 1st of November, at which the assigned judge, Judge Saltykova, dismissed my client's jurisdiction challenge, and thereby established as a matter, it will be said, of Russian law res judicata, that these arbitration rights are null and void under Russian law and public policy. That judge has all the materials that she needs to move forward to give judgment on the merits, because these are claims under 7 guarantees or bonds. They're all demand bonds and all the documents before the court. So there is a very real risk now that on the 14th of February, if not restrained by final mandatory anti-suit injunction, my client will have judgment entered against it and execution measures taken against its assets in Russia. Now, first of all then, before turning to Russian law, I wanted to make 2 very quick observations. That there is quite a bit of law in the authorities bundle, but some of it is, in a sense, going further back than perhaps needs to be the case. So you have Spiliada, but you also have VTB and Nutritech, Vedanta, and the Huawei litigation in the Supreme Court. It won't be necessary, I don't think, to go through that in detail. The test is what it now is said to be by the Supreme Court, and we will look at that briefly. So I don't see this as being a law-heavy analysis. When we get to the case of Enka, obviously one of this panel has familiarity with that litigation, having been in the Court of Appeal in that case. It is a very long judgment. What I'll aim to do in the time available is to track through what I see as the core steps in the reasoning. That could take a little while because it is such a long judgment, but I will endeavour to give a simplified, if not simplistic, tour through that extensive judgment when we get to it, including the minority judgments, so far as they assist. I was going to say that about authorities. The only other thing I was going to say by way of observation is I wasn't planning to structure my submissions by reference to the errors we say the judge below took. We have set those out in the appeal skeleton pursuant to which permission is granted. And it will be apparent in my submission that if you understand and accept our raw analysis on the 2 points, the errors of the judgment below will be apparent from the difference between that raw analysis and what the judge said. Now, with that in mind, I'll turn to the position in Russia, if I may. And could I ask the court, please, to take up supplemental bundle B, I called it B1, it may be labelled the same way for the court. There are 3 features of the current Russian legal landscape that I wanted to emphasise based on Russian law evidence which is uncontested. It's uncontested in the sense that we led evidence as to what the Russian legal position is, and it wasn't gainsaid by the reply evidence served by RCA in the course of the 5 or 6 weeks between it being served and the trial. So there was Russian law evidence from RCA, from a Mr. Petrol, but he didn't cover any of the points that I'm about to tell you about. Those 3 points, just so you know what they are firstly, that the enactment of Article 248 of the Arbitrage Procedural Code, or APC for short, in the middle of 2020, as interpreted broadly by the Russian courts in the meantime, effectively constitutes an abnegation by the Russian Federation of its responsibilities under international law according to the New York Convention by overriding arbitration rights and ignoring an arbitral process insofar as sanctions are engaged. That's proposition 1. Proposition 2, the Russian courts have extensive powers to grant interim, preemptive, coercive remedies to stop the use of foreign courts and arbitral processes. Pursuant to the same Article 248, they have shown their readiness to do so, and that would manifest, we say in this case, in the grant of an anti-arbitration injunction to stop any arbitration in Paris if it were to be started, the grant of any anti-suit injunction if the Russian court was given that opportunity by the lifting of the current interim protection. And that would be backed by something called astraint damages, A-S-T-R-E-I-N-T-E, or penalty, which is the Russian court's version, or we might call that the Russian court's version of contempt, the contempt regime. So if a party is injuncted and breaches the injunction, it is liable for the full value of the claim by way of astraint damages. The third proposition is that any award that could be obtained after however long it would take to obtain it in arbitration would not be enforceable in the Russian courts because it has ceded to itself exclusive jurisdiction, because there would be a res judicata once the substantive claim had been entered, and no doubt RCA would contend there is already a res judicata on the arbitration position as a result of the dismissal of the jurisdiction challenge there.
We haven't got that ruling, have we? Does it exist in writing?
I don't think it's in evidence before the court.
No, it's not, but does it exist?
I dare say it does, my lord. We just haven't sought to put it in evidence. It's common ground that the jurisdiction challenge based on the arbitration rights was dismissed on the 1st of November.
Right. Well, it might be useful to see it,
yes,
unless there's some objection to that.
Very well, we'll do our best. So very briefly, if I can ask you in bundle B1 to go to tab 13. to this was the Russian law memorandum that was filed and served in support of the application in August by my client. I'll just ask you to go to Exhibit A at bundle page B135. There you have set out in translation text of Article 248. There's a couple of other articles of the APC, as I'm calling it. Article 248 is in two provisions, Article 248.1 and Article 248.2. And the key provisions for our purposes are 248.1, small 1, small and sub-small 2, if I can put it like that, which confer upon the Russian courts exclusive jurisdiction in the following cases. One is disputes concerning parties affected by sanctions, if I can paraphrase, and the second one, more expansively, as engaged here, is disputes if the grounds for such disputes are restrictive measures, i.e. foreign sanctions. And that has been engaged by RCA in seizing Russian jurisdiction here because, of course, the bank's, my client's refusal to pay out on demand under these 7 bonds is essentially based on EU sanctions. If I can ask you just to track down to 3, small 3, so we're still under 248.1, small 3, small 2, that looks forward to the next provision, 248.2, and that is about the ability to apply for preemptive measures, what we can loosely call in this case an anti-arbitration injunction. And then 4 is the crunch provision in a way. 4 is the provision that deems inoperable any arbitration agreement where the existence, if it is the case that the existence of foreign sanctions create, and this is the final words, obstacles to access to justice for such a person. So what the Russian legislature has done is it has enacted a deeming provision that deems inoperable arbitration agreements where a Russian entity says it cannot get access to justice in arbitration as a result of sanctions. And that's precisely what RCA has sought to say and has achieved in saying last November before the Russian court. And then finally, small 5 is the provision which shows quite clearly, we say, that a foreign arbitration award rendered in such circumstances will not be enforced. Because the only situation in which a foreign court or arbitral award rendered in such circumstances will be enforced in Russia is if it's the party affected by the sanctions themselves, the Russian party, who starts the arbitration or doesn't object. Well, neither of those is the case here. And then 2482 is the provision that deals with court powers, and very briefly it's small 1, the last few lines, an application for a prohibition to initiate or continue such proceedings. So that's an express conferral on the arbitrage court of power to injunct foreign arbitration. It hasn't been used yet because there is no arbitration, but if our protection falls away, because we're told we have to go to arbitration, we all know what's going to happen. They're going to go to the Russian court and injunct it. And in 10, this is where you see the reference, although I'm not sure the word appears, to what I've foreshadowed is the estraint penalty. This is the court's power to levy effectively a fine or penalty on a party that breaches one of its preemptive orders, up to the amount for which the foreign arbitration relates. So it's entirely possible that in a claim under the bonds for 450 million euros, if this court doesn't grant the mandatory final anti-suit relief that we need before the hearing in the middle of next month, judgment will be entered for 450 million euros plus interest on the main claim. Any attempt by my client to start an arbitration in the meantime, if we're told that's what it ought to do, and there's many reasons why it shouldn't, will be injuncted by the court in Russia. If my client ignores that Russian court's injunction, it could be then on the hook for another 450 million euros in estraint damages from the Russian court. You would have res judicatas on jurisdiction and substance being used against my client in that arbitration, as well as an injunction from the Russian court backed by estraint damages. That is a nightmare.
Does paragraph 10 mean that you'd have to pay twice over? One
That's the
slide.
evidence, which we can look at very
Is it?
briefly now.
All right.
And on that, if we can just jump
Well,
back.
it may not matter because paying once over is bad enough for you, I suppose.
It is.
But why does the grant of a final anti-suit injunction in this country make any difference?
Well, that, if I may say so, isn't a usual concern of the court when it exercises that power.
I understand that, but can you tell me in practice why it makes a difference?
In practice, this court, as in the commercial court in London, grants final mandatory anti-suit injunctions to restrain the pursuit of Russian litigation, which result in the withdrawal by the injunction defendant as a local plaintiff of that litigation. That's how it works. And the Russian law evidence shows that that's how it works. And what we have here at the moment is an interim order, which is negative. So for the meantime, RCA as claimant in Russia can't do anything to advance its cause. But of course, the court has all the paperwork it needs now to opine on 7 claims under on-demand guarantees. It has all the paperwork. So if you were sitting in the commercial court and you had all that paperwork, you're in summary judgment territory, aren't you? Because you have English law bonds with all the paperwork. So the negative protection gets us something, in the sense it stops RCA pitching up on the 14th and saying, please give me judgment. But the judge has everything that she needs already.
Well,
Whereas a mandatory compels them under pain of English contempt, which the evidence so far suggests they do take seriously, the RCA, the English contempt regime, to take a positive step to withdraw and discontinue that claim. That's why the mandatory final relief is so important. That's why the commercial court expedited in 5 weeks this action. And it's why Mr. Justice Henshall, 1 week before the trial on the 22nd of September, refused an adjournment application that the defendant made because he understood the risk was imperative. And what is imperative and what the legitimate interest is for a claimant in my client's position is to get that mandatory final order, because that's the silver bullet for the unlawful and vexatious foreign proceedings.
if the Russian company doesn't comply with the injunction and doesn't withdraw the claim in Russia, will the Russian court continue with the hearing of the Russian claim?
It's a very good question. I don't want to speculate what Judge Saltykova will do. There are judges and there are judges sitting in the arbitrage court in Russia, and some are more hardline than others, if I can put it like that. I don't want to give evidence
So we
where
don't
this
know.
judge slots in. But there is evidence of Russian law to suggest the court of its own motion, when faced with a final mandatory injunction, may feel an inhibition about entering judgment, even if it hasn't been discontinued or withdrawn from the file. I wouldn't wish to put it any higher than that. It is sometimes the case at the very end of the whole process, when you're talking about the final mandatory relief in anti-suit jurisprudence, that the utility or lack of utility of the order can feature in the debate. But that's only really in cases where there is a palpable absence of utility in the English court granting its order, which is not the case here. It is a matter of surprise to me, sometimes personally, that the Russian court does heed in Norrie Holdings, which my Lord Justice Males did at first instance some years ago. The judge granted a mandatory final anti-suit injunction, and the Russian court heeded it, and the party. So it has value, and it is deemed to have value unless proven otherwise. I'm conscious of time, so I've made
There are 2 other cases where interim injunctions have been granted. Have those cases, do you know, progressed any further towards final injunctions?
Well, they are, in a sense, both sitting behind this jurisdictional appeal at the moment.
Are they?
So they haven't been progressed at first instance. We obviously have the Deutsche Bank Court of Appeal decision on the ex parte interlocutory. In both of those cases, arbitrations are on foot. But I think I can say this safely on the evidence before this court. Neither of those banks appears to have gone to the court and with evidence that it has exposed assets in Russia. Whereas the evidence from my client, which I'll show you in a moment, is it has exposed assets in Russia. Now, obviously, business organisations took their course post-2014, when the first wave of sanctions came in, Regulation 833/2014, post-Crimea. A to the extent to which they wanted to continue to do business in or with Russia and Russians. UniCredit is a German headquartered bank that for one reason or another continued in that business policy. It has executable assets in Russia. And so it is in a different position from Deutsche Bank and Commerzbank, I can say that. And if you want the reference for that, it's Mr. Claypool's first witness statement, which is B tab 11. We should just look at it in passing. And it's paragraph 38, A, Roman 6, which is on bundle page B94. It's the last 5 or 6 lines of that sub-paragraph. And whilst we're in that witness statement, if we just forward to page 99, can I just ask the court to note paragraph 47A, which was evidence given that any award would not be given recognition and enforcement, again, contrary to the New York Convention, if rendered contrary to the Russian court's view of the enforceability of the arbitration rights, by reference to its own public policy. Again, that evidence given in August last year and not gainsaid by Mr. Petrol or in any other evidence served by RCA.
You, or Mr. Claypool, distinguishes in that paragraph between final relief and emergency arbitrator relief. Obviously, final relief would take some time. Emergency arbitrator relief would be quicker. Is there any law on whether an order by an emergency arbitrator counts as an award under the New York Convention?
My understanding is it does not. It's an order itself until it becomes an award, which is a process in itself. And as I will address you when I come to proper forum later, but I foreshadowed already, the process of getting an arbitration to the point of an award, even if it's an anti-suit award, not a substantive negative declaration on the bonds, is going. We can all today see how fraught that is going to be, because RCA as arbitral respondent is going to object to jurisdiction. It's going to use the dismissal of my client's jurisdiction challenge in Russia, no doubt, to say there's a res judicata between the parties on the unenforceability of the arbitration rights. And it's going to use the substantive judgment, if it gets it in February of this year, to say there's a res judicata on the bonds, as it were, whilst proceeding to execute €500 million against my client in Russia. So there's a delay problem with an arbitration. If you can't get to an award because of that delay, assuming that they haven't injuncted through the Russian courts the arbitral process in the meantime, of course, then you're left with an order that is, we called it toothless, perhaps that's the wrong epithet, but it's an arbitral order that you can't do anything with. It is common ground that the French courts, as curial courts, have no equivalent of our Section 42, so you can't take an arbitral order in Paris or in France to the court and turn it into a court peremptory order with contempt backing. You can't do that. So you're stuck with an anti-suit order from an emergency arbitrator, which you probably won't get to anyway if we don't have the protection of our anti-suit here to stop the use of an anti-arbitration injunction, which will be fought tooth and nail by this Russian recalcitrant, invoking res judicatas galore in the process. Delay, delay, delay. And it will take us a year, and it will be worth nothing. So we're here in the English court because we say you have jurisdiction and you have the remedy to stop all of this happening. That's why we are here.
Paragraph 48, after paragraph 47, rather suggests that in fact the likelihood is the Russian courts would not of its own motion accept and act on the anti-suit injunction. It is dependent on RusChem deciding to withdraw its...
It does, to answer my Lord's earlier question.
So then it's a question of, do they have assets here, do they have directors here that we can enforce the order against them?
Yeah. In fairness, I don't think that tracks what is said in the Russian law advice on that matter. And it's an empirical matter. It depends, I think, on the judge, on the judge's view of the English order and whether the English order is appropriate. I think it's enough. If there's any possibility of practical utility to a final anti-suit relief, it is granted. It's if there's no possibility of utility, I think the court pauses at that point saying, well, why should I do this? Why should the court act in vain? If this is all equity at the end of the day, why should I exercise my equitable jurisdiction to achieve something which, or rather to do something which achieves nothing? But those are slender cases, and it's not the empirical experience in Russia. Can I just, I'm not going to go back into the Russian evidence because I'm conscious of time, but there is the evidence unchallenged is that there is a substantial risk of an anti-arbitration injunction being granted by the Russian court, if not restrained by this court. It is currently restrained by this court because we have an interim negative injunction currently held over under section 24 of the CJJA because we lost all jurisdiction and this is a pending jurisdiction appeal. So it's still in place and it has as part of its terms effectively an anti-arbitration injunction and an anti-suit injunction, if I can put it like that. In other words, this injunction from this court at the moment stops RCA going to its court to get its own counter-preemptive relief. I did want to show you corroboration of that in a recent authority. It's a case of Rensok. It's another Russian anti-suit case. If you could take up the authorities bundle and go to tab 21.
You know which authorities bundle?
Oh, is it split?
Split in three.
Tab 20, I suspect, will be in the second half if you have it in two halves.
Hard pressed to get them all into one bundle.
It's tab 21. This happened to be an English seat case, but there was a citation of the Deutsche Bank decision in this current trio of banking cases, and that was at paragraph 35, it's a judgment of Mrs. Justice Dias. We don't need that so much. She comments in 37 that what the Deutsche Bank case shows, and we'll look at it in due course, is a strong predisposition of the English courts to enforce and uphold arbitration agreements. And in a sense, we know that. Paragraph 41 to 43, I was showing you because it corroborates the Russian law risk. And if you could read 41, then I think you can jump to the bottom of 43. Now, I won't attempt to pronounce the gentleman's name, but what the court there accepted evidence that it's not possible to enforce an arbitral award in Russia, which contradicts a local judgment. So you can anticipate that the RCA will argue you couldn't enforce any award either because it contradicts the jurisdictional ruling already rendered as to the unenforceability of arbitration rights, and a fortiori if it contradicts the substantive judgment, which is looming, possibly as early as next month. Can we then turn these to the statement of claim or complaint in the Russian proceedings? And that is in supplemental bundle B1. This is an agreed translation. I'm going to attempt just to go through it quickly and in a sense highlight the parts that matter rather than asking the court to read it, conscious of time. It is a claim, as you see.
Which tab?
Oh, so sorry, it's tab 9. There's a summary section of 3 paragraphs which shows you, in a sense, why we're here and that is because it's a straightforward, undeniable breach of the arbitration. It is a claim for payment under 7 bonds to the tune of 444 million euros plus different elements of interest. In circumstances where all 7 of those bonds contain an arbitration agreement, covers this claim. It is the most axiomatic, if I can use that phrase, breach of an arbitration agreement you could ever have. And of course that feeds into the forum debate when we get to it, which is that this is not a breach of contract trial, as it were. When one comes to us, well, what is this case? What is this claim? What's the dispute? What is the matter to be tried for the Spiliada test? The answer is not, is there a breach of contract? That is not a matter to be tried in this case. The matter to be tried in this case is whatever strong reasons my learned friend's client can concoct to try and resist the grant of anti-suit relief in circumstances where the breach is manifest. And you get that from the very opening paragraph of this statement of claim. They are claiming under the bonds in the Russian court. Why? Because they say sanctions allow them to do that. And you see that prefaced in paragraphs 4 to 7. And what they're really relying on is that second limb in their paragraph 5 there, that second limb I showed you, Article 248.1, small 2, that the dispute relates to bonds. Because RCA is not itself subject to sanctions. Sorry, the dispute relates to bonds. I meant the dispute relates to sanctions. So they are asserting in the Russian court that they are sanctioned, but that is incorrect. What they're also asserting in the Russian court is that the dispute, i.e. the non-payment by my clients under the bonds, is related to sanctions, and they're using that as a jurisdictional hook into Russia. And you see that then recapitulated in 13, that the European sanctions violate public policy. If you go forward into paragraph 21 on bundle page 61, you see a recitation, unnumbered, of some of the clauses, which includes the penultimate bullet point over the page, the English law, followed by clause 12, the arbitration agreement. But there is no attempt anywhere in this statement of claim to apply English law. So it's not just that they're going to the Russian court and saying, oh, please override arbitration rights. They're also going to the Russian court saying, please override English law. Because what they are saying is, on both of those limbs, both jurisdiction and substances, in Russia, you don't recognize EU sanctions. The EU sanctions are a violation of the Russian constitution and Russian public policy. Therefore, A, seize exclusive jurisdiction under Article 248. B, give us payment out order under the bonds, because sanctions is not a defense. So the mere recitation that English law was chosen by the parties to cover the bonds is window dressing. They are ignoring English law as well as ignoring arbitration rights.
If the case ever got to an arbitration, would there be a question in the arbitration whether, under English law, the EU sanctions, which, as I understand it, are EU and not UK sanctions, gives the bank a defence?
I dare say that would be a defence, or rather a substantive issue in the arbitration if it ever got to that stage.
Yeah, yes, I see.
Yeah, but that would be for the arbitrators. That's the whole point of arbitration.
Yes, quite.
And as I foreshadowed earlier, one of the strong reasons advanced by RCA to resist the final anti-suit is that they would get a better deal in Russia, or the Russian courts, on that issue than they think they would in Paris arbitration, to which we would say, that's anti-suit litigators, so what? There is always a motive for someone to breach their promise, always. And when you're breaching your jurisdictional promise, it's always because you think you'll get a better outcome in your home court than you would in the forum that you agreed, promised that you would go to. So that's a so what point. And if that was right, very few anti-suits would be granted, because the defendant who's breaching their promise would always be able to say, yes, but I might get a better result in the unlawful forum. That's just not how it works. But there we go. If we trot through the rest of this, I wanted to show you the key provisions where they attack the public, or they make the public policy points. And you see that heading, starting under heading B on page 65. Obviously the heading tells you most of what you need to know. You probably don't need to know the details of the Russian civil code that support it. If you then track through that section, you'll see with the culmination in paragraph 53, there is the allegation that the application of sanctions as a defence to payment under the bonds is contrary to the public policy of the Russian Federation. Then you get to C, which is the invocation of the court's jurisdiction. So this is the plea, as it were, under Article 248.1 of the APC. And you see the same points then made again around sanctions and the violation of constitutional rights to show why the Russian court should take exclusive jurisdiction. You see that made in two ways. Firstly, in C1, because the existence of sanctions in the dispute confers jurisdiction, exclusive jurisdiction, and in C2, on bundle page B70, you see the plea that they can't get access to justice. So therefore what they are seeking to invoke is Article 248.1 small 4 that we looked at a short while ago, which is the deeming provision that an arbitration agreement is inoperable where it impedes access to justice. And what RCA tell the Russian court is that they can't get justice in a French arbitration because they can't instruct lawyers in France, they can't attend a hearing in France, the sanctions are so terrible, notwithstanding the fact that they are not in fact a sanctioned entity, notwithstanding the fact that they are here today, or in the court below, are defending the Deutsche Bank claim, are defending the Commerzbank claim with London lawyers and Paris arbitration. This is what they tell the Russian court. And the Russian court has accepted all of this, and has accepted jurisdiction on this basis. And that raises something that we have called the Russian season premise, because we say it's an abuse of process for a party to come before this court, having invoked and obtained a jurisdictional finding in its favour in a foreign court, on the basis that arbitration is unenforceable and impossible and ineffective, and then come to this court and resist an injunction which forces it to be held to that arbitral promise by saying precisely the opposite. Because so much of what my learned friend will say to you on forum posits a situation in which arbitration is enforceable, effective, and available, whereas his client has told the Russian court it is unenforceable, unavailable, and ineffective, and has won on that point. And we say that's an abusive process. Now, whether you say he's shut out from advancing the opposite premise, that's a matter for the court. Highly unattractive. We say it's unconscionable to do that. We made the point to the judge below. He wasn't particularly interested in that. Let's finish on the statement of claim, because in a sense you've got what you need. If you flick to the end, so that's bundle page B77. Just before that, you've seen the prayer for relief, which is basically payment out under the bonds plus interest. You have a whole series of documents attached, 30 documents, which include the demand letters that were made under the bonds and everything else. Judge Saltykova, or rather I should just point out, before that, if you go to bundle page B74, you will see that they sought an early preliminary hearing. So speed is of the essence for RCA in Russia. They filed this on the 5th of August. They got that first early hearing on the 14th of August, a week or so before we came before Mr. Justice Knowles on the ex parte injunction in this court, in this country. And then the judge adjourned that to the 27th of September. And that's why we had our expedited trial in the court below on the 22nd of September. The idea was we would have a final hearing in the commercial court with enough time to obtain a mandatory injunction which we could translate into Russian following Monday and deploy prior to the hearing in Russia on the Wednesday, the 27th. But we didn't get our final order. We maintained our negative interim order. And what happened at the hearing on the 27th of September is the judge adjourned it again to the 1st of November. But also what happened on the 27th of September is RCA filed more documents. Now, it could be said that the filing of more documents by RCA on the 27th of September was a violation of the negative interim anti-suit injunction from this court. It could be said to have been doing something to advance its claim. But we don't take that point. don't say they are debarred, and we haven't commenced a committal application against them. But what it does tell us is that the judge now has everything she needs, because on the 27th of September she had the file topped up, if I can put it like that, by RCA. Let's leave aside the rights and the wrongs of them having done so, but they gave the judge the final document she wanted, so she has the whole file she needs to enter, as I say, a judge in the Rolls building would grant summary judgment on a claim like this. You just have to see the bonds and see the demands. And that's that. And then what the judge did on the 1st of November, conscious that this court had by then listed this hearing for today, is adjourned to the 4th hearing in Russia on the 14th of February, as I say. So we can put that document away and go to the bonds.
The judge had my order, did she? Giving permission to appeal?
The judge was informed, I'm assuming, at the 1st of November hearing that there was going to be a Court of Appeal hearing in this court. It would be listed on the 24th. Whether she saw my lord's permission order, I don't know.
Right.
But as part of our little project of finding out precisely what the record is of that hearing, we will endeavour to give the answer this afternoon. Can we turn then to the bonds? They straddle the two bundles. There are 4 performance bonds. They are bonds 1, 4, 5 and 6, as they've been numbered in this litigation. And bond 1 appears at the end of the main appeal bundle, bundle A, in tab 16. The other 3 bonds, 2, 3 and 7, I think, or whatever the numbers are, appear at the beginning of bundle B. If we take up tab 16 of main
I think that's another reason actually why I would like to see the order of the 1st of November, because I did express the hope in my permission to appeal ruling that the Russian court would not determine the merits of the claim without giving a reasonable opportunity for this appeal to be heard. And if the court did take that into account and fix a date with the knowledge of that, then I would be very interested to know exactly what was said to the judge and what the judge has said.
I understand that, and I can understand that specific inquiry. Yes.
You haven't submitted to jurisdiction, presumably in Russia, have you?
No, I haven't submitted.
To jurisdiction, you're not represented and you're not appealing the Russian court proceeding.
I'm not aware of any step having been taken on jurisdiction since the dismissal on the 1st of November of my client's arbitration-related jurisdiction challenge. The bonds, I was aiming to do this off just one of the bonds, bond 1 at the back of the main appeal bundle, but there are differences that we would encounter between the 2 sets of bonds. Can I ask you to take up tab 16? So this is bond 1, which is a guarantee of Linda's performance. Linda, L-I-N-D-E, as you appreciate, is the main contractor, who was to build the 2, let's call them power plants. So 4 of these bonds guarantee Linda's performance. And 3 of the other bonds are advance payment guarantees. Now the first thing to note is that nowhere in this document is there a definition of the bond. That may or may not matter when we come to the textual analysis of clause 11, but it is a point my learned friend takes, because the whole debate we're going to have here is really about the meaning of clause 11. This is the Enka bond. What does the reference to this bond, or rather, what does the use of the phrase this bond in clause 11 mean? Well, the answer is it means what it says in its context. So what you do have in bold on the first page is 2 references to what the document or the contract is. Performance bond number la-di-da, 75 million odd euros. You see that repeated in bold on the first page. And then you see, dear sir or madam, this bond, so that's the first reference to this bond, is made on the 3rd day of August 2021. All the bonds were made in the summer of 2021, 7 years after the enactment, I can call it that, of Regulation 833 of 2014. And that's the primary sanctions instrument enacted by the EU. So these are all made against the backdrop of that regulation. So when it says this bond is made on the 3rd day of August, that obviously is applying to the whole document, is it not? Including clause 12. It has 5 recitals Recital 2 says, according to the conditions of the contract, this bond is required to be provided. Again, a reference which would clearly be to the whole of the bond, including clause 12. And the guarantor hereby provides the bond to the beneficiary. Recital 3 says this performance bond. So there is no precision or consistency. Sometimes it says this bond, and on this occasion it says this performance bond. If you look to the operative provisions, you see the uppercase heading operative. Paragraph 1 is the language, the primary language of suretyship that you would expect. And it's an obligation to pay on demand. The form of that demand has to be in writing substantially in the form of Annex 1 to this bond. Where does Annex 1 appear? If you jump forward to page A130, not surprisingly, it comes after clause 12. And that's because it's an annex to the bond, and that's because the bond is clauses 1 to 12. The bond is not clauses 1 to 11, or indeed clauses 1 through to the end of the first sentence of 12, which is my own friend's position, potentially. And then paragraph 2, clause 2, refers to demands under this bond, 3 payments under this bond. It is at this point that the advance payment bonds depart in their numbering, because there's a clause 4 in the advance payment bonds that comes in here, and then it skews the numbering. So clauses 4, 5, 6, and 7 of this bond are clauses 5, 6, 7, and 8 in the other bond. Nothing turns on that. Clause 5 is potentially important. It says the language of any document specified in this bond must be English, or else translated. And then clause 6 is the one that my own friend relies on quite heavily, which is to do with, let's call it duration. This is the sort of clause one often sees in contracts, even when they do have arbitration agreements, which is the duration clause. This bond shall come into force on the day it was issued, and shall remain valid until either X or Y. The expiry of the bond shall not affect or discharge the liability, etc. So what my learned friend says is, well, if the phrase this bond is used to refer to something which expires or terminates, it can't include the arbitration agreement. But of course the answer to that is the references to this bond just take their meaning from their context. If you flip forward to clause 12 itself, you see wording which you see so often in arbitration clauses. The second sentence, the nexus wording in arbitration agreements always refers to the agreement as defined anyway. All disputes arising out of or in connection with the bond. So the use of the word the bond there isn't talking about the arbitration agreement. Well, certainly that's not what the parties are primarily focusing on. They're talking about issues of substance, disputes of substance that have to be referred to arbitration. So the phrase the bond, under the bond, this bond, just take their meaning from their context. We did a trawl of the clauses in the agreement in the Kababi case, which we'll come to in due course, and it turns out that the contract in the Kababi case had all of these sorts of clauses in it. It had termination clauses, assignment clauses that talked about this agreement expiring and terminating. It's standard stuff. It's just the way people draft contracts. What it doesn't mean is you can then roll the use of the phrase this bond in clause 6 into clause 11 and say, clause 11 is only talking about the operative or substantive provisions. It can't be talking about clause 12. It doesn't work like that. It's all about context. And then if you look at clause 9, we get a real problem from my learned friend. Clause 9 regulates the assignability and formalities of assignment of all rights and benefits under this bond. Now that must be a reference to clause 12 as well. Otherwise, you would have the horror scenario of the parties having regulated the assignability and formalities of assignment of everything apart from the arbitration agreement through this express clause, itself governed by English law, but not regulated the assignability and formalities of assignment of their arbitration agreement. That is contrary to the notions of English law, that when a party signs a contract containing an arbitration agreement, the assignee takes the benefit and burden of the arbitration agreement with it. It creates the horror scenario that you might end up having split disputes. You might have to arbitrate, if there's a disputed assignment, you might have to arbitrate against the assignor, RCA, the beneficiary, but litigate or find yourself in litigation against the assignee who took the bond from RCA. Your arbitration would be applying English law to the validity of the assignment. Your litigation, wherever it takes place, would be applying whatever law that court chose to apply to the validity of the assignment. And that is just a horror. So that is my learned friend's position. So my learned friend has a real problem with the phrase rights and benefits under this bond in clause 9. We say that has to apply to the arbitration agreement. The contrary is insufferable and cannot be what these commercial parties intended. And then you get to paragraphs 11 and 12.
Is this, as you understand it, really the RCA position? I don't know what the arguments were below, but unless I've missed something, which is very possible, I don't find the arguments you're now contesting in Mr. Hussein's skeleton.
No, they're not. He relies on clause 6. The only textual point he takes, other than in clause 11 itself, is in clause 6. It appears as clause 7 in the other 3 bonds because of the numbering issue. And he says, because there is reference to this bond expiring or terminating, therefore the phrase this bond must have a singular meaning throughout. I rely on clause 9 because when you go through the bond, you see clause 9 causes a real problem by way of rebuttal to that point.
Mr. Hussain?
My Lord, I thought I might be half invited to state my position. I apologise for interrupting my friend. My Lord Justice Mills is right. Our case is this, which is common ground, is that this is an implied choice case. So you have a situation where you've got a standard form of clause that applies the governing law to the main contract law. We accept that that gives rise ordinarily to an inference that the parties may have intended to apply the same law to the arbitral agreement law. The debate is not, or not principally, about the terms of this clause, although we do refer to them defensively to some of my learned friends' arguments. The debate is about the curial law carve-out. What does the court do in circumstances where the principle at paragraph 170, Roman 6 of Enka applies?
Or, well, I know that's at the heart of your case. I thought this was a point on what Mr. Houseman was saying was your case on the meaning of this document.
The reason this matters so much under Enka,
Yes.
Let's just jump ahead slightly and
Yes.
contextualise this. Enka recites the 3-stage common law test of the English private international law for ascertaining the governing law of a arbitration. Stages 1 and 2 are express and implied choice. It's very difficult to know in any given case whether there is an express or implied choice. As an aside to that observation, in Kababi, the first instance judge and the Court of Appeal found an express choice of law, English law, to govern the arbitration agreement, whereas the Supreme Court omitted or declined to say whether it was an express or an implied choice. It's a notoriously fine line between the two. But that is a purely English contract law inquiry, searching for a choice. Now, when it's not explicit, the arbitration agreement itself doesn't say, I am governed by law X. You're in the territory of whether or not there is an implied choice through a choice of law clause in the contract itself. The way that choice inquiry works is you have to look to see how strong the inference is to start with. If you have a strong inference that the parties chose, in this case, English law to apply to clause 12, then you need a strong rebuttal. And you might find that strong rebuttal if you saw something in the record that showed, under the curial law carve-out, that the parties chose arbitral seat X because the arbitration law of country X contained a provision in its statute that supplied an alternative choice of law mechanism that English law recognised as a choice of law mechanism. It's a very limited form of renvoi that Enka permits, but it's a very confined form of renvoi that requires the local arbitration law to supply a recognisable and equivalent choice of law mechanism, like the Scottish Act does, and the Swedish Act does in a different way, and the English Act is about to when Section 6A comes in. So, but this is all about a search for choice. At this point, you've put dicey down, and you've picked chitty up, and you do the thing that we all do and have done for decades now, which is we look at a bunch of terms, and we decide what one of them means in context. And the inquiry of this court, with chitty in its hand at this point, not dicey, is to look at this bond with 12 terms and ask whether, and the extent to which these parties indicated a choice of English law to cover clause 12, or the second sentence of clause 12, in fact. And if you find that they did but fell short of it being an explicit or specific choice, as it's not in clause 12, then you have to look for something very clear and meaningful in their choice of Paris seat to countermand that. This is all just contractual interpretation. It's a single unitary process. And all I'm doing at the moment is taking you through clauses 1 to 12 to show this is a very powerful case of implied choice, which would need a very powerful contraindicator that choice of seat meant choice of some other legal system. It wouldn't even be a system of national law, so it's actually not even the right sort of law, but we'll come on to Enka in a moment. So clause 9 is the real trouble for my learned friend on his, what I might call, semantic approach to the phrase this bond, because on any rational reading, rational business people would say that all the rights and benefits under this bond included their arbitration promises. Because if they don't, like I say, you have a horror scenario of split litigation, split law, and split outcomes. You then get to clause 11. This bond and all non-contractual or other obligations arising out of or in connection with it shall be construed under the governed and governed by English law. That is as wide as you can get, either because clause 12, all of it, and certainly the second sentence of it, or rather including the second sentence of it for our purposes, forms part of this bond, which we say it does, or come what may, it is one of the other obligations arising out of or in connection with it. These parties went out of their way to make their choice of law as wide as they could. The only thing they didn't do was say in clause 11, including the arbitration agreement in clause 12 below, or say in clause 12 itself, this arbitration agreement is governed by English law subject to clause 11 above. That's the only thing they didn't do, and that's why we're having this fight. But it's a very clear case of implication. You then get to clause 12, which is 2 sentences. Well, it's 3, happens, but it's in 2 parts, effectively. The first sentence of clause 12 is nothing to do with arbitration. It's a mutual obligation to attempt to settle. It's clearly governed by English law, pursuant to clause 11. So on my learned friend's case, you have the condition precedent to arbitration, which is the mutual obligation to attempt to settle, governed by English law, but the validity and scope and meaning and life of the arbitration agreement in the second and third sentences of clause 12 governed by something else. And of course the something else is rather the point of this case, because it wouldn't be governed by a system of national contract law. So how could that displace the choice in clause 11? Right, I better get a move on. I'm conscious I'm making the points ahead as I go along. Sometimes how it works.
Building up to the grand climax of looking at Enka.
I was going to say some words about French law, which is my third heading, and then deep breath, and then Enka.
Right.
French law, there's an awful lot of common ground, so I wasn't going to give you references to this, but I'll give you 5 propositions. First of all, the French court won't grant, probably because it can't grant, an anti-suit injunction in a case like this to restrain the pursuit of Russian proceedings. Let's not get into any nuance around that. That is a broad proposition which holds good for our purposes. The second proposition that flows from that is that that's not because of any philosophical or juridical or judicial hostility on the part of the French legal system or those who discharge French justice, French judges, let's call it. And that has been said in evidence in the Deutsche Bank case. That's Professor Davout, as accepted by the Court of Appeal in the judgment we'll look at. It's been said in the Commerzbank case by Professor Audit, believe those two professors co-author the French equivalent of Dicey and Morris. It is said by Mr. Onley, on behalf of my client in this litigation. He was co-author of the French law opinion before the Supreme Court in Kababi, as it happens. And indeed, it is not gainsaid by Mr. Kaminsky, the defendant, RCA's expert on French law. He's a French lawyer. So we've moved past that point of thinking that anti-suits are somehow inimical to the French judicial way of thinking. We're not in that territory. If it was the case that the grant by this court, as non-curial court, of an anti-suit injunction to restrain a Russian proceeding in circumstances where, on the basis of an arbitration agreement that chose France's seat, if that issuance of that remedy was offensive to the French legal system or legal way of thinking, I can well see why this court would feel inhibition in granting the relief. It may not be relevant to jurisdiction, but I could see how that would be a serious comity issue, but we're not there. But that's fallen away. Proposition 3, not controversial. The French court has no equivalent of Section 42 of our Act. We touched on this a while ago. The practical implication of that is that any arbitral order for anti-suit relief will end as an arbitral order. It cannot be converted into a French court order, and the French court's contempt regime cannot be engaged to back it and give it value. Therefore, it is toothless. The fourth proposition, which flows from that and is common ground, is that the arbitral tribunal itself, by giving that order, has no follow-up powers. There is no sanction for the disobedience of that arbitral injunctive order. And then the fifth proposition, which in a sense is the biggie for Enka, but which is not controversial, is that some time ago, 3 decades ago, in the Dalico decision, the French legal system abandoned a conflict of laws approach to ascertaining the validity and meaning of arbitration agreements, and instead it adopted something known as the substantive private international law model, or the substantive principles of international arbitration, which have nothing to do with seat. If any matter comes before any French court relating to the validity, scope, meaning, or subsistence of any arbitration agreement, and unless the parties have stated in it that a national law governs that arbitration agreement, the French court, any French court, irrespective of arbitral status, will apply substantive principles of international arbitration, which look to the common will of the parties. It's simply an inquiry into the common will of the parties. And that is crucial when we get to looking at this exception to Enka. Because if you are going to displace a choice of a national system or a system of national contract law to govern your bargain in favour of some other law supplied by a conflicts of laws mechanism in a statute that is applied by dint of your choice of arbitral seat, it has to be an equivalent conflicts of laws mechanism in that arbitration statute at place of seat. Because if it's not, then what the Supreme Court did in Enka, without even using the word renvoi, is that they opened up a potentially huge and uncertain aspect of renvoi, notwithstanding the fact that they went out of their way in almost 400 paragraphs to create clarity in our law, with so much emphasis on certainty, coherence and simplicity running through all three, I should say, the judgments of the 5 justices. And the idea that they sneaked through the back door, having told us how difficult dépassage is, and all the uncertainty that dépassage creates when you split the law within one contract, the idea that without using the word renvoi, which is notorious to all private international lawyers for the uncertainty and incoherence and complexity it creates, through this backdoor exception, would be astonishing. It just would. The idea that you can just resort to the Dicey and Morris in force at the law of seat to provide a set of delocated, non-seat based principles that determines whether you have a valid arbitration agreement and what it means, in order to displace a choice of English law or choice of national law to govern your contract, would be an extraordinary outcome, and is not one contemplated by Enka. I jumped ahead ever so slightly.
Well, I suppose you would say, we stick with jumping ahead for a moment, that if the search is for the common will of the parties, then you've got to look in the contract, and in the contract they say English law.
I would say that in a well, I would always say yes to any proposition my lord throws my way, but well, almost. I would say
not accept it if it's unsound.
No. I would say this is intuitive as someone holding a chitty in their hand, to use the metaphor. If the parties have said our relationship is governed by this system of national law, then intuitively, if they're going to be found to have chosen a different system of law to govern part of their relationship, you would need something very clear to indicate that choice, or to contraindicate the choice they've used words for. And what this carve-out does, or this exception, which really gets most of its life from the summary in Enka. You don't even see it in the analysis, really, in Enka. It's given form in the summary, is a very limited exception that if you allow to be applied in the case of piracy, given the French private international law approach to this, would just turn Enka upside down. Because the whole point of Enka was to straighten out the mess, if I can put it like that, caused in the Court of Appeal by C&D and Sul America, going different ways on this debate. And then the Court of Appeal in Enka did its best to wrestle with that at the same
But its best turned out to be not good enough.
Well, now the Law Commission is saying something else, but that's for the future, for when that statute is enacted or amended. So there, I've jumped ahead slightly, but in some ways there's a lot to be said for taking Enka and compressing it into those raw terms, I think. We'll come to that in a moment. Can I just finish on French law? There are two aspects of French law which are not common ground, but neither actually matter, or matters. The first is whether an English anti-suit injunction could or would be recognised and enforced in France. There is a debate between Mr. Kaminsky for RCA and Monsieur Onlay on behalf of my client. But on Monsieur Onlay's side, we have Professor Davout on behalf of Deutsche Bank and Professor Audit on behalf of Commerzbank, all saying the same thing, which is an English anti-suit would be recognisable and recognised in France. So we win that battle, as it were, on the evidence. But all wrapped around that, I would say, so what? It is not a meaningful inquiry on the part of this court, either on the jurisdictional issue or when it comes to exercise its final remedial equitable discretion to ask whether its order will be recognised in France. I understand my Lord Justice Lewis's inquiry about whether it would be heeded in Russia.
Yes, because that's where the claim is. But this is directed either to the claimant or the court hearing the claim, not to the court.
It's directed to the injunction defendant in its capacity as claimant or adjutant in the Russian proceedings in which it is acting unlawfully. And English anti-suit law has squared off the comity issue on that, historically, angelic grace, etc. So we don't need to go back over that. But it is not a meaningful inquiry to ask whether this court's final anti-suit order would be recognised in France. The only meaningful inquiry would be if it was offensive and contrary to the public order publique, or public policy in France. And of course, the experts all saying no, it wouldn't. So that's a sterile debate. That's one of the two strong reasons which are advanced by RCA to resist the grant of final relief. So you can score that one through. The only other issue that's left, therefore, about the issue of French law is, in a sense, not a French law issue. It's an English law characterization of French law. My learned friend cites, and the judge adopted this, the Supreme Court decision in Dalla, and also the subsequent Supreme Court decision in Kababi. But of course, the reason why, and I'll respond to this depending on what is made of it, the reason why the Supreme Court in Dalla, Lord Mans, described these French private international law principles that we're talking about as part of French law was because the inquiry was into whether or not that was the law of the sea. It was an enforcement case under section 1032B of the 96 Act, which replicates Article 5.1a of the New York Convention, where in order for a court to enforce a foreign arbitral award, it has to be satisfied that it's valid according to the law of the seat, or according to the law selected to govern it by the parties, if that takes precedence. And so the only issue in Dalla, which actually wasn't even a controversy between the parties, was, well, are these French private international law principles of discerning the common will of the parties, are they the law of the sea? Are they French law for the purposes of being law of the sea? Answer, yes, hardly controversial. It doesn't help you answer the English common law private international law question before you, which is whether the parties can displace a choice of English law to govern their bargain through some form of renvoi mechanism and replace that and substitute it with something which isn't a national system of law or a system of contract law.
Could you just explain to me, were those cases saying that the rules of procedure governing the arbitration, which may be the International Chamber of Commerce rules, that those procedure provisions just covering how the arbitration was conducted, were they saying that that was part of French law, or were they saying that French law encompassed more than just the rules of procedure governing the process of the arbitration?
It's not entirely clear what they're saying about that. So in other words, are they saying that the French Dicey and Morris is French law, or are they also saying the French Chitty, although it isn't Chitty, it's something that we now know is completely different from the Chitty? It's not entirely clear, but I don't rely on this. I'm just trying to head off the point that's been made. The judge was quite attracted by this below. In a sense, you can imagine a judge being, because you can say, well, I've got two Supreme Court decisions telling me this is French law. So why is this such a problem? Why can't the parties have constructively...
My question is, what is French law? Because you've got the contract, you've got the arbitration agreement, and you've got what I call the rules of procedure. How many days do you have to put in your claim? How many days to respond, and so on? And it wasn't clear to me when I did look at those cases in reading for this, whether those cases were saying simply the latter third part, the rules governing process, weren't just international arbitration principles. They were either were or were treated as part of French law, or whether they were saying something else about something to do with whether the arbitration agreement was also French law, or, well, they weren't saying anything about the contract.
I don't know if it's entirely clear, but I'm not relying on that. I'll hear what my learned friend says and maybe we debate that. I didn't want to burn time because I would have burned quite a bit. What I would simply say is you have to ask what the purpose of the characterization is. The purpose of the characterization of those principles as French law by Lord Manson Dalla was in order to satisfy themselves, the court to satisfy itself that that was the law of the seat for the purposes of section 103(2)(b). So in other words, that body of case law we can call the law of the seat. Likewise, or similarly, in Kababi, it comes up right at the back end of the analysis because it's all about res judicata. The final question before the Supreme Court in Kababi, when we look at this, when we look at the front end of Kababi, is, well, are we bound by what the Paris Court says as curing cause over this Paris seat arbitration, over validity and scope of the arbitration agreement? In that case, whether a company that acquired the original contracting party was bound by the agreement.
Well, Kababi, from your point of view, is the dog that didn't bark, because
it is, absolutely. Yeah.
Yes,
Absolutely. You can see where I'm going to go. If my learned friend's point was so good, why didn't counsel raise it in Kababi? Why didn't Lords Hamlin and Leggett, fresh from issuing Enka and referring to Enka, take this point? There are 2 points taken in Kababi as to why the choice of English law didn't implicitly roll into Article 14 in that case. They were the other way around, weren't they? Choice of law, Article 15. And those 2 points, one of them involved going into Article 14 itself and seeing the UniCredit choice and saying, well, that muddies the waters. And therefore, it isn't just English law. That was bad. And the other one was the validation principle, the repugnancy principle. But what was staring every single lawyer in the face throughout Kababi was my learned friend's point. And no one thought to take it. Paris seat does not give you French law. And insofar as it gives you something which you can call French law for other purposes, it doesn't supply what English private international law requires you to find. And this is where we will start on Enka, because the whole point of Enka, and you get it from the first 2 paragraphs of the judgment, and you see it in the Law Commission's discussion as well, is that English private international law looks for a system of national contract law to govern a contract. Like it or not, that's just the way we do things in this jurisdiction. The French don't. Vive la différence. But they don't, and the fact that they don't is fundamental to this whole Enka point. It is, in fact, the short answer to all of this, because it is one thing to displace a choice through words of a system of national contract law to govern your bargain via a constructive choice of another system of national law supplied by a statute, which is mandatorily applicable at the place of seat. That is one thing. It's still renvoi, but it's a very contained version of renvoi. It is a fundamentally different thing to displace that choice of the system of national contract law with something which is not a system of national contract law, which is what the French, for better or for worse, is what the French system has chosen to do. And we get all of that from the opening 2 paragraphs in Enka. Deep breath, let's go there. It's tab 15 of the authorities. The first point to note, insofar as it goes, is that the headnote doesn't deal at all, doesn't mention at all what we're calling the curial law carve-out. Interestingly, the headnote, after the per curiam, when it says per the majority, Lords Hamlin, Leggett, and Lord Carr, says factors which might indicate that the arbitration agreement is intended to be governed by the law of the seat include the existence of a serious risk, etc. So the headnote, for what it's worth, only extracts the so-called validation principle. And of course, when we come to the summary in Enka, paragraph 170, we see the validation principle as factor B in the same Roman 6 subparagraph that we see this carve out, the choice of seat carve out, as factor A. They unfortunately get lumped together. If I was to make, well, my learned friend reserves the right to say Enka is wrong at a higher level, and that tells you something about the logic of his own submission, which is he would like to rotate the entire cadence of Enka and turn choice of seat to be primary over choice of law in the main contract. But if I was to make a criticism of Enka, it's that the summary in paragraph 170 isn't cross-referenced. It would be awfully nice if their lordships had cross-referenced those propositions, because then there would have been much less debate in this case, for example, about the origins and the scope of the factors of the curial law carve-out. We've had to do that work ourselves. And B, it would have been, I think, an awful lot clearer if they had not lumped factors A and B together and then wrapped them around with that comment about neutral seat, because the neutrality of the seat applies asymmetrically between factors A and B, as we pointed out in the reply skeleton. But pausing there and dwelling on the validation principle, it's really just, again, we're holding chitty at this point. We're looking at a contract, and we're saying, and as English contract lawyers, we're saying, well, that choice, if that choice of law applies to the arbitration agreement, these parties will have inadvertently frustrated their own legitimate expectations. Because to take Sul America, Brazilian law choice in the reinsurance, Brazilian law doesn't allow a party to go to arbitration in a contract of adhesion, unless both parties agree to go to arbitration for that specific dispute. So Brazilian law, mandatory Brazilian arbitration law, takes away the very thing that your words in your arbitration agreement were conferring, which was a unilateral right to go to arbitration. It nullifies the value of those words chosen. And we're all familiar as English contract lawyers with the concept of repugnancy. Mackay and Dick and Eton College and Algassane, they mean through implied terms and purpose of construction, a party isn't allowed to frustrate the ability of its counterparty to perform. Repugnancy is a well-known principle of contractual interpretation which finds acute form in exemption and limitation clauses. You cannot, through exemption clauses, nullify the content of your primary obligations. And when you say something which is repugnant to the purpose or scheme of your contractual endeavour, the courts would interpret that in a narrow way to achieve the sense of what the parties set out to get. And all the validation principle is intuitive to a contract lawyer. It's entirely intuitive. You don't, if you have a choice of law, you don't roll it into the arbitration agreement if that choice of law would frustrate the arbitration agreement, as illustrated by Sul America. And therefore, it's not surprising to see the headnote writer extract the validation principle and put that in as a factor that can negate or curtail the extent of your chosen law, but they didn't put in the so-called, what we're calling the Cura Law carve-out. Lord Burroughs didn't countenance the Cura Law carve-out, he just said it would be exceptional. This is paragraph 257, Roman 4. He said it would be exceptional for the choice of seats to trump the choice of law. And Lord Sales, who in a sense sat above the majority and the minority and commented on the differences between their two judgments, doesn't deal with it at all. As far as Lord Sales is concerned, it's only the validation principle, i.e. the repugnancy, the concept of repugnancy, that would stop a choice of law in the contract rolling into and covering the arbitration agreement. It would only be if that was inimical to the choice of arbitration. Now, paragraphs 1 and 2 is where you get the basic concept set up. What paragraphs 1 and 2 in the majority?
And you've mentioned that the head note doesn't give much of the point in the judgment, which is an issue here. But just starting with it, for those of us who, unlike you and my Lord Justice Males and no doubt Mr. Hussain, know this case by heart, is there anything in the head note which is wrong?
Not that I know of.
All right.
No. Paragraphs 1 and 2 set up the three, let's call them the three laws or types of law that are in play in the situation where you have an arbitration agreement contained in a main. So in other words, an arbitration clause. You know, the law governing the substance of the dispute, i.e. the contract, the law governing the agreement to arbitrate, and the law governing the arbitration process. They go on to say the law governing the arbitration process, sometimes referred to as the curial law, is generally the law of the seat. These two systems of law may differ from each other. Each may also differ from the law which governs the validity and scope of the arbitration agreement. And then this, paragraph 2, the central issue on this appeal concerns which system of national law governs the validity and scope of the arbitration agreement. And that's because no authority is needed for that proposition because it's so fundamental to English conflicts, English private international law, which is that contracts are governed by a national contract law, a system of national contract law. And where the parties have chosen national contract law X to govern their contract, that choice would only be contraindicated through some mechanism of constructive choice by reference to an arbitration statute at the place of seat, if that contained a conflicts mechanism that the English system recognised as equivalent and which also supplied a system of national contract law. We just don't have that with France. That's the French answer to the Enka point, if I can put it like that. But it's fundamental. You see that reflected if you go forward in when they discuss the three-stage rule in paragraphs 35 and 36. They make the point in 35 that there's no sharp distinction between express and implied. But we all know an express choice of law for an arbitration agreement when we see one, because it's either in the arbitration agreement itself, which I think is becoming an increasingly more popular choice for advisors, or else that you could have a situation in which the choice of law clause made it clear that it's also applied to the arbitration agreement for the avoidance of doubt. That's an express choice. That's irrebuttable. If you have an express choice, it's game over. The parties have literally chosen it. It's game over under the French system, for what it's worth. Because in the French system, those supranational principles would yield to an explicit internal choice of a national system of law, as we know. Then, when they're countenancing the default rule, the closest connection rule, if you see at the end of the first sentence, the old juridical conception was that that was a form of imputed choice. The law, English law has moved away from that in the meantime. It now looks at a functional connection test. But the old imputed choice would be for a law, for the contract to be governed by a particular system of national law. So you see the same phrase repeated. It's also pausing there on what the Law Commission regard as the fundamental inquiry or focus inquiry of English private international law. If we depart from Enka briefly and go to the Law Commission consultation or final consultation report, final report recommendations, that's in tab 32 of the authorities. And it's paragraph 12.4. Contract law guides us in resolving disputes about contracts. Where there is an international dimension to the contract, we need to identify the country's contract law, which country's contract law will be relevant. So that just echoes what is said in Enka. The focus of inquiry on the choice limbs, is for a system of national, i.e. contract.
What's the date of this report?
I don't know whether the index helps with that. It's the most recent one that led to the recommendation to enact section 6A. I don't know the date off the top of my head. It was certainly in the last, I think, 6 to 8 months. And if we go back to Enka, what I was going to do, because I'm conscious of both time and the need to get through a big judgment, is to distill this into a series of propositions that is, in a sense, that supports the logic of all 5 justices' appeal, but which we will see predominantly in the majority judgment itself. The first of those propositions, the one I've just covered, which is the necessary focus of inquiry under English private international law, is to search for a system of national law, which means a system of national contract law to govern a contract. Like I say, that's just a fact of life. English private international law does that, other systems don't. The second proposition is that in order to conduct that search, you have to become an English lawyer, because you are an English judge. And we get that from paragraphs 33 and 34. And as occurs so often in the field of private international law, you need to break the circuit somewhere. And my Lord Justice Males will be familiar with this. There's a danger in private international law of an analysis chasing its own tail and going round. And you have to find a rational and coherent way of saying, no, I'm going to jump in here. And when we come to the forum discussion, we will see that the whole forum discussion in this case is influenced by proper characterization of this claim. And so what an English court has to do, as a matter of English private international law on forum, is it has to jump in and say, I'm going to say what this claim is. And in order to do that, it uses common sense, and it looks at the thing in front of it, and it applies an approach of substance, not form. It doesn't look to see what parties call their pleading, or call a claim in their pleading. It doesn't look to see how parties describe their claim. It looks to see what the issues are in the claim. My Lord Justice Males did that in Norrie Holdings when he looked at the claim under the Russian bankruptcy statute. He said, as an English judge, I have to look at what the claim involves as a matter of substance. I have to look to see what those issues are, and I have to look to see whether they are issues that an arbitral panel can deal with. And so that's an example of that. In the recent Privy Council case of Family Mart, the court says when you're looking under Section 9 of the Act to stay court proceedings because they should be referred to arbitration, whether that's under the English Section 9 or the Cayman Section 4, you look to see what the claim is about. You look at the substance of the claim. And so too under Spiliada, all the way through to Huawei. In forum, you have to get a jumping in point, and it's about the court looking at the substance and looking at the issues and deciding what is this claim about? What's the trial going to be about? And so too here. When you are looking
Mr. Haslam, sorry to interrupt. You rather tantalisingly said that Enka could be encapsulated in 5 propositions. And wouldn't it be better to tell us what the 5 are?
Absolutely.
Right.
Yeah. I'm conscious of basically collapsing the forum discussion into quite a short one later by getting ahead, but maybe I shouldn't do that. But also what I'm doing is showing you that this is, again, a fundamental approach of English private international law, that to break the circuit, you have to become someone. In this case, you have to become an English contract. I'll tell you what those propositions are now, if it's easier to signpost.
I think so.
The first one we dealt with, which is the search is and must be for a system of national contract. The second one I'm on is that in order to conduct that search, you have to conduct an English contract law analysis. Why? Because you're in England, and the only way we know how to do it is to hold you to, as it were. Stage 3 is that the short one we looked at, proposition 3, is that express and implied choice are not easy to separate in practice. Choice is choice. Proposition 4, and this is a key one, is that there is a general presumption that parties would not desire different systems of contract law to govern different parts of their bargain. There are a whole range of practical reasons, some given more fully by Lord Burrows, as to why that is the case. So in other words, English private international law is hostile to dépassage. Proposition 5 is that choice of seat is about other things. It is not about the choice of law. That has various strands to it, and that's where we see the references to the foreign statutes which form the basis of this exception. Proposition 6 is that there is a limit on choice. That's the validation principle.
What was your proposition 5? What is your proposition 5?
That the choice of seat is about other things. In other words, a choice of seat can be explained by other practically desired outcomes or circumstances rather than a choice of law for the bargain. Choice of 6 is that there's a limit on, proposition 6 is that there are limits to choice. And that is the validation principle that we could also just call repugnancy. The parties may choose something, but that choice may not be the one that they truly intended to have. And then proposition 7 is only really applies to situations where there is no choice, and we're not in that territory because the parties here did make a choice of law. But what we will see, very briefly, even there, is that when you default to the seat, according to the majority, when you default to the choice of seat as supplying your closest connection in the absence of any choice, the rationale that underpins that is still legal certainty. So running all the way through all of these propositions is an insistence on legal certainty, coherence and simplicity. Let's go to proposition 4. We pick that up in paragraph 39. There's a heading Roman 7, splitting the contract. And if I can ask the court just to read on paragraph 39. So as a general proposition, it's undesirable to have different systems of contract law governing either different parts of a single contract, or indeed your main contract versus your arbitration agreement contained within it. There are more practical examples given as to why that is undesirable or incoherent in the judgment of Lord Burrows. And if you just go forward to paragraph 235. You see a heading, Roman 3, dividing the arbitration agreement from the rest of the contract may be problematic. And the examples that he gives in 235, which you see just above G, are entire agreement clause. The next examples he gives, 237, he covers a situation about the admissibility of pre-contractual negotiations. And in 238, he deals with no oral modification clauses. NOMs. So what he's showing there is that in a standard or average contract, you might have one or more of these clauses, which we might just add assignability and conditions on assignment, which we have in clause 9 here, where if you were to split the governing law, you're going to have a problem on your hands. Because the example, to take pre-contractual negotiations, if the contract is governed by English law, and English law doesn't allow you to look at pre-contractual negotiations, you're going to get one answer. But if the arbitration agreement is governed by New York law, and it does allow you to, then you're going to get a different answer to that. You compound that problem when you have multi-tiered dispute resolution clauses with conditioned precedents in them, which we have here as a two-tier clause. Sometimes you have a three or more tier clause. It's good faith negotiation followed by mediation, followed by arbitration. And you can't contractually go to arbitration until you've exhausted the two before. But they're not arbitration agreements, so they're governed by the governing law of the contract. And then you get into a right-all pickle, because then you can't look at pre-contractual negotiations to construe limbs 1 and 2 of your 3-limb dispute resolution clause. But on the split contract approach, you can look at it, if it's, say, New York law, to do that. And so, and I illustrated that point by reference to clause 9 earlier here. You end up in a real difficult situation if you have to split both your forum and your applicable law between your assignor and assignee in a disputed assignment. It cannot be what these parties contemplate. So, and you see that therefore, at the top of paragraph 40, that you need good reason. You know, there is an intuitive desirability to having a single system of contract law governing your bargain, and you need a good reason not to. Now, a good reason is supplied, or at least could be supplied, by the separability of the arbitration agreement. It has a different life. It may not have a different birth, but it has a different lifespan, potentially, than the agreement itself. But separability only gets you so far. We'll come on to that. If you go over the page to heading Roman 4, choice of law for the whole contract, this theme is continuing. This section culminates on paragraph 53 or 54, and 53 is crucial, but so is 43. In paragraph 43, they recite what they call a typical clause. This agreement shall be governed by and construed in accordance with. And they say that it is natural to interpret such a clause in the absence of good reason to the contrary. Again, you need a good reason, as applying to the arbitration agreement. And we see that echoed in paragraph 60, albeit in a further section, but they refer back to that. They say, as we have discussed, well, that's a reference to 43. And then they say what they say in the rest of that paragraph. And 53, well, they deal with Kababi as it was stood in the Court of Appeal in 52. And as they say there, the decision in Kababi is reinforced by the fact that there was a definition of this agreement. But that was only a fortification or a reinforcement. It wasn't. It isn't vital to the outcome in Kababi. Then you have considerations of principle above 53, and this is vital because this is where the rationale is set out. And what you see under a series of subheadings is effectively the incantation or the invocation of certainty. Certainty, consistency, avoiding complexity, avoiding artificiality, and ensuring coherence. And therefore they conclude, as a matter of principle and authority, there are strong reasons why an agreement on a choice of law should generally be construed as applied to the arbitration agreement. So that's what supplies the presumption. That's what supplies the momentum. And it all depends on how strong the choice is, like I say. Where you have a strong choice, a clear choice, with less ambiguity in it, a clause following on from the other one, using the same nexus language that these two clauses do. They both use exactly the same nexus language, so they look like they are related. Where you have a conditioned precedent that is clearly intended to be governed by that choice of law, which is then stitched in to the arbitration agreement itself, you have a clearer and stronger choice, which requires a much more robust rebuttal. And paragraph 53 is important because in 3 places in Lord Sales's judgment, I'll just give you the references, paragraphs 286, 290, 292, he refers back to paragraph 53 in terms. So it's paragraph 53 supplies the principle, which is intuitive, because if you choose a law to govern your bargain, you've chosen the law to govern all of them. Then the next proposition is seat. Seat is about other things. And this is under the heading of the approach of the Court of Appeal, because as my Lord Justice Sales will obviously recall, the approach in the Court of Appeal was different. The approach in the Court of Appeal was to say, well, curial law about the process of the arbitration tends to get mixed up with other provisions in an arbitration statute. Look at the 1996 Act. And therefore a choice of seat, which is a choice of curial law, which is a choice of the package of state regulation of arbitration, the 96 Act in this country, means that by choosing seat you have constructively or indirectly chosen something that the seat supplies. And it's the mixing together, or the so-called overlap between that. So what this section does is it deals with, well, actually, what are you choosing when you're choosing seat? You're choosing other things. And we see that in paragraph 68. They have the heading above 65 of the overlap argument. 68 is a discussion about an example that was before the court to do with if you go to drive in France, are you choosing French traffic law? And they say, well, that example is what it is, but choice of arbitral seat is something else. So everything in 68, from the words by contrast down to the bottom, and certainly the last two sentences, are important. Choice of seat is choice of curial law, which is the law that governs the process of arbitration, and it's choice of a court system that will supervise that arbitral process and will determine the validity of awards made under it. That's what you choose when you choose seat. And very often parties choose seats because they're neutral, of course, but they're choosing a neutral curial court in the process. What they're not doing by choice of seat, or certainly not obviously so, is choosing to have the law that governs their arbitration agreements supplied by that law of the seat. And to make that choice elliptically or constructively or imputedly through this carve-out requires something very definitive in the local arbitration law, so that the parties can be said to have chosen or opted in to a local statutory conflict of laws mechanism that supplies them with a substitute system of national contract law to govern that arbitral bargain. That's what this comes down to. And you see an echo of what they say in 68 in paragraph 143. It may be just for present purposes, you just note that. And can I ask you also to note that Lord Sales discusses the implications of a choice of seat at 271 to 273. So the key takeaway here is that choice of seat is about other things, or denotes other things. And paragraph 69 sets up the discussion that follows. As noted at the beginning of this judgment, the curial law which applies to the arbitration process is conceptually distinct from the law which governs validity and scope. Whether a choice of the curial law carries any implication that the parties intended the same system of law to govern the arbitration agreement must depend on the content of the relevant curial law. That's a phrase my learned friend seizes and says, aha, that's quite wide, that's quite general. But of course, it all depends on what follows. What follows then, in paragraph 70 to 72, is a discussion of the Swedish section 48 and the Scottish section 6, followed by the comment that we don't have such a thing in our Arbitration Act, as to which now see the Law Commission, and the prospective section 6A. Pausing there and looking at the two provisions, if we could, in both Sweden and Scotland, they are found at the back of the authorities bundle. Towards the back. The Scottish section 6 is tab 26. Law governing.
The examples which the Supreme Court give of when this curial carve-out, as you call it, would apply or might apply, both happen to be statutory. proceedings, but is there any reason in principle why a sufficiently clear rule derived from case law should not equally apply? I mean, I appreciate you say that the French rule is not, so you don't need to address that in answering this question. But suppose, for example, the position of the Court of Appeal in Enka had prevailed. Why would that, or its equivalent in case law of a foreign country, not be sufficiently clear to satisfy this exception?
Well, I think this comes back to the deepest rationale about what this is about. This is about a search for a choice. And of course, the language they use when they summarise this, when they recap it as factor A in their summary paragraph, is a provision. They actually say a provision. And I understand the argument, which is, well, they only say a provision because the only two examples they're given are statutory provisions. But that is not a coincidence. If you're searching for a choice to be implied constructively from choosing seat, then what you're doing is you're effectively compounding a series of 4 or 5 choices. It's like I choose seat, therefore I choose seat X, therefore I'm taken to have chosen curial law X, therefore I'm taken to have chosen the package of state regulation of arbitration in jurisdiction X, because that contains curial law X. Inside that package of state regulation, let's call it a statute, but it could be a section of a civil code, but it's a codified arbitration law, I will find a conflict of laws mechanism that English private international law recognises as broadly similar to our own way of doing things. And therefore I've chosen that. So I've chosen seat, curial law, arbitration statute, conflict of laws mechanism. That supplies me, that mechanism, with national contract law X. Therefore, I've chosen via those 5 stages, I've constructively or indirectly in a compound way, taken to have chosen national contract law X through that mechanism. Because you can just about conceive that parties are deemed to know the statute, the arbitration statute at the place of seat. It might be a reason they've chosen it. It might be. And therefore, you can infer a choice.
Lord Hoffman says that parties can fairly be taken to have come to London because anti-suit injunctions are available. Well, they're not a specifically statutory provision, other than the very general provision in the Senior Courts Act, but nevertheless, there are things that, in his view, people can be taken to know about when they choose a London seat. Why not a similar sort of rule derived from case law?
Because this is displacing a choice that the parties have made through words. This whole inquiry takes place because the parties have chosen a law, a system of national contract to govern their bargain. And the only question that arises out of that as English contract law is, well, what's the extent of that choice? Does that choice also include their arbitration agreement? And if the only thing set up against that clear choice is the fact that they are deemed to have opted in to a clear and mandatory conflicts mechanism applied by the courts of the arbitral seat, which then supplies a contrary choice, then you need something pretty compelling. But there is also then, of course, the policy argument that if you don't confine it to that, you have renvoi opened up in a way that creates much uncertainty. And that's why I was going to show you the Scottish Act, because the Scottish Section 6, and I would say, is all that actually the carve-out should be covering. Because if we look at this Section 6, that's tab 26 of the authorities, it goes out of its way to contain its application. It says where the parties to an agreement, arbitration agreement, agree that an arbitration under that agreement is to be seated in Scotland, but the arbitration agreement does not specify the law which is to govern it, then unless the parties agree otherwise agree, the arbitration agreement is to be governed by Scots law. So it is seat specific. In the Scottish case, unlike the Swedish case, and unlike, I believe, Section 6A, once the Law Commission resolved that particular debate, the Scottish section says if you choose Scotland as your seat, you get Scots law. Point 1. So in other words, it's a seat. It's something you can say the parties chose by choosing seat. pausing there and contrasting it with French law briefly, that is not what these French law principles do. They have nothing to do with seat. They are simply that if the validity of any arbitration agreement comes before any French court, they will apply these delocated international principles. So the Scottish Act, in my submission, is the one that this carve-out should be limited to, because it's about the choice of the place, the seat, that gives you the choice of the law, and therefore that attributes some meaning to the choice of the seat. And the second aspect of that is it's only displaced by, as it says in small b, a contrary choice in the arbitration agreement itself. So what you don't end up is another layer of renvoi, which is the only reason you're in this inquiry to start with under English private international law is because you've got a choice of some kind and you're asking how far the choice goes. You're going to create an awful lot of difficulty if you then look to a statute, an arbitration statute at the place of seat, which also defers to some kind of woolly choice. Because at that point, you've got the English court saying, well, I've got to decide as an English lawyer what has been chosen, and I'm going to defer to the Zimbabwean arbitration statute, which also defers to choice. What's the answer to that? You're going to end up having Zimbabwean law experts in on jurisdiction, every jurisdiction challenge. So what the Scottish statute does, which the Swedish one doesn't, and which French law certainly doesn't, is it says, well, it yields to a choice, an internal choice. In other words, it tells you what an express choice is. That's why I wanted to show you that, because my submission is that the carve-out should really be limited to that, because that is still renvoi, but you can just about see how that is a containable form of renvoi. Anything beyond that is potentially uncontainable. And uncontainable means uncertain, complex, and incoherent, which flies in the face of the rationale of Enka in both the minority and the majority judgments. So if we put the Scottish section away and return to Enka, you have that discussion in 70 to 72, and the comment there is no similar provision, so that's the word provision there at the top, and 72. You then have a discussion which I think we can probably jog past about the proper meaning of section 4.5 of the 96 Act. I don't think we get an awful lot beyond, and that culminates in paragraph 94, which again is important. I know my learned friend relies on it. While a choice of seat in curial law is capable in some cases, based on the content of the relevant curial law, of supporting an inference that the parties were choosing the law of that place, the content of the Arbitration Act doesn't. And of course, that's in the context of section 4.5 discussion. So you have to ask, well, what do they mean by the content of the relevant curial law? They use that phrase bookends this whole section of the judgment. You see it in 94 and 69. But of course, the only discussion you find within those two bookends are the Swedish section and the Scottish section, and the fact that it doesn't appear in the English Act at the time. Indeed, that's what Lords Hamlin and Leggett said to the Law Commission in their letter to the Law Commission, which has gone in, I think, at the very last tab of the authorities bundle. I'll see what my learned friend wants to make of that, because they put it in. But they were quite clear with Lords Hamlin and Leggett that the examples they gave were statutory provisions. Now, again, what does it mean? But this all comes down to rationale. You then get discussion of the validation principle. That starts at paragraph 95, in other words, avoiding invalidity, on which, again, we don't really need to worry too much about, because it is intuitive, as I say, to English contract lawyers. It's a repugnancy principle at heart. Lord Sales also deals with that at paragraph 277, because as I indicated earlier, Lord Sales only countenances a single exception. He doesn't countenance both exceptions that you see summarised in the small 6 of paragraph 170. He only countenances validation as reflected in the headnote, as we saw. And then you get a section, paragraphs 118 through to 146, which is all about applying the default rule under the common law test. It's Roman 8. Applying the closest connection test. And as I've flagged, this is proposition 7. As I flagged earlier, that doesn't really matter so much for our purposes, save insofar as the emphasis there, again, is on certainty. And one of the supporters for that certainty rationale was the fact that it broadly assimilates with Article 5.1a of the New York Convention as brought into domestic law in Section 103.2b. In other words, you look at choice first, followed by law of the seat second, and therefore the English common law approach broadly corresponds to that, because the arbitration agreement, absent any choice, will have its closest connection with the place of seat, the arbitral seat. And that was a point of difference, of doctrinal difference between the majority and the minority. They disagreed on why Russian law governed the construction contract and what the implications were, but they also disagreed on that very narrow aspect of private international law. They disagreed on the default, which is less interesting for our purposes. We then get to paragraph 170, conclusions on applicable law. It may be useful to summarise, they say. So we know this is a summary, and therefore we know this cannot extend beyond what has gone before. And Roman 1 to 3 are, in a sense, dicey points, if I can put it like that. So in other words, they are English private international law, and we see repeated in Roman 3 there, the jumping in, breaking the circuit point that we saw in paragraphs 33 to 34. You have to jump in some way, you have to break the circuit, and you do it by being an English contract lawyer. You look at the contract, you look at the choice of law, and you ask yourself whether it either expressly or impliedly covers the arbitration clause. If it doesn't do so expressly, then you move on. So Roman 4 to 6 is then the chitty inquiry, if I can put it like that, once you've adopted that stance and undertaken that inquiry. And you see there replicated and reflected the presumption that we saw, with all those good reasons behind the presumption, and therefore the need to negate the inference. So Roman 4 to Roman 6 stand as a package or a set of English contract principles, albeit being applied in the private international law context. And then you get to 6, and like I say, if I was to criticise Enka, I don't say it's wrong, my only friend wants to, but if I was to criticise Enka, I would say 6 should have been separated out into 2 propositions, not of equal weight, because the validation principle is far more intuitive to an English contract lawyer as a rebuttal mechanism of choice than the choice of seat is. And the danger of having lumped them together is it creates the impression that they are of equal rebutting force when they are not. That impression is regrettably reinforced by the rider to Roman 6 about neutrality, because the way neutrality of choice of seat operates is different in each case, as we explained in the reply, skeleton. But come what may, you have to look to see how it starts. There's additional factors which may, however, negate such an inference, and may in some cases imply that either the arbitration agreement was intended to be governed by the law of the seat are any provision of the law of the seat. And you know what we say about that. This is all about certainty. This is all about avoiding an open-ended renvoi. This is actually about a statutory conflict of laws mechanism in the arbitration law of the place of seat, which indicates that where an arbitration is subject to that law, and then there's a typo, at least in my law report, the arbitration, it should say agreement, will also be treated as governed by that contract's law. And the treated as is doing quite a lot of work there. The phrase treated as is that 5-stage compound choice that I described a while ago. I choose seat X, therefore I choose curial law X, therefore I choose the package of state regulation of arbitration in country X, therefore I choose a provision within that state regulation which supplies a conflicts of laws mechanism, which supplies a national law. Therefore I am treated as having chosen national law X. 5 stages, constructive choice. And you have to ask yourself, is a constructive choice like that worth as much in the minds of business people, given that they have actually made a very simple choice and a clear choice to have a law, a simply single national contract that will govern their bargain already? So the thing that is looking to rebut the choice has to be powerful enough to rebut the choice that's indicated by the words that the parties actually did choose. And as I say, choice of seat denotes many other things. So, to conclude on Enka, we say that that carve-out is very limited. We say it would be a surprising result given the entire thrust and logic and direction of Enka if it turned out that by choosing Paris seat, you rebutted the inference of your choice of law. And that's because, for the very simple intuitive reason, where business folk go to the bother of choosing the law to govern their own bargain, that has a powerful momentum in terms of how much of their bargain they have chosen to be covered by it. And let's not forget, curial law is about the law of the process. The law of the process of arbitration involves a whole web of multilateral and bilateral contracts between each arbitrator and each party, as well as between the parties. It involves a second set of contracts which are referred to as the reference to arbitration. Curial law governs that web of relationships, that process of arbitration. And therefore, choosing your curial law to govern a web of relationships is not the same thing as choosing a system of contract law to govern your bilateral contract at the time you enter into it. So they aren't even the same qualitative choices. So it would be surprising in that sense because it turns Enka on its head. It would be doubly surprising because it would introduce renvoi without it having been discussed in Enka. And not just renvoi in a Scottish Section 6 really limited way, which you could just about conceive if Scotland was a neutral seat, but in a way that's totally at large. Because if my learned friend is right, this carve-out allows you to call witness evidence, expert witness evidence, from lawyers at the place of seat to tell you, the court, what their version of dicey contains. What does the law of country X, Y, and Z do as a matter of private international law here? And that is the worst example of renvoi. I know I should be careful. The worst kind of renvoi is the one where it pings all around the world, or it pings backwards and forwards. The classic renvoi never stops, because country X says look at country Y says look at X. That's the nightmare renvoi. It's not that. But what it is having the roles building clogged up with multi-day jurisdiction challenges in every case where parties have chosen English law and foreign seat arbitration, if there isn't an arbitration statute that's definitive on this, because everyone is going to be coming along, calling experts and saying, this is our version of Dicey and Morris, and under our version of private international law, this is how we do it. And jurisdiction challenges are going to go from 4 hours to 4 days, and this court's going to be hearing a lot more about them. So there's a policy aspect to this.
Now, speaking of time,
yes,
it's 25 to 1. I hope you're going to be able to sit down at 1. So what topics are still to be covered?
Forum, but I've flash forwarded a wee bit into it, and I plan on doing that in 20 minutes. So I wasn't planning to sit down at 1 o'clock.
Good.
I'm just looking at the judgment of Sir Nigel Teare again in paragraphs 23 and 24 and 25, and fitting what you've just said with why you say that judgment is wrong. You seem to say 25 is wrong. It fails to recognise what you've just said, that the choice of the rules governing the arbitration, even if they are to be treated as French law, doesn't negate the higher level a priori choice of the law governing the agreement, including the arbitration agreement.
Yeah, well, our specific criticisms of the judge's reasoning are set out in 4 stages in our appeal skeleton. And I don't want to, in a sense, go back over that. We say the judge erred. The principal error of law, of course, is not confining that carve-out to a statutory provision, because that's clearly what the law of the Supreme Court justices had in mind. It's what this judge, Sir Nigel Teare, understood that they had in mind, but then went on to say that it meant something else. So his principal error of law was to construe the carve-out in a way that was legally impermissible. Having done that, he then applied a French system of law that is non-seat specific and wasn't therefore capable, even in its own terms, of giving this contraindication, because French law has nothing to do with choice of French seat, unlike, say, the Scottish provision. So if you choose Scotland for arbitration, you choose Scottish law unless your arbitration says otherwise, the arbitration agreement. So there's a multiple set of errors of approach there, And of course, he ultimately has substituted in the Sir Nigel through this mechanism of renvoi, something which isn't a system of national contract law. So it's wrong even on the French law approach as well. Kababi, briefly, it sounds to me as though this court has some familiarity with the judgment already, so I was going to, rather than go to it, just make the submissions very briefly about it. There is a choice of law clause in Kababi which fits the classic or standard choice of law clause that discussed in Enka at 43 and 60. It has that fortification wording of saying this agreement shall include all the terms. But that is very much icing on the cake. You can see that from the ratio on issue 1. Like I say, my Leonard Jr. did a trawl for other clauses in the Kababi case, and we did find that Article 11 and Article 19 and Article 25, not all of which find their way into the Supreme Court decisions, include those sorts of usual clauses you see, a bit like the one my learned friend excites about in the bonds here, saying this agreement shall terminate on this date, or if this happens, this agreement shall terminate. But those clauses didn't trouble the Supreme Court in reaching a very emphatic decision that was a par excellence choice of English law to govern the arbitration agreement in Article 14. And then, of course, you have the 2 points. This is the sleeping dog or the barking dog, I can't remember. The 2 points which are taken in Kababi are, first of all, to say there was no choice, or rather the choice of English law was diluted and rebutted because the arbitration clause referred to the application of UniCredit principles. And the answer to that was that doesn't dilute the choice of English law or rebut the choice of English law. And the second point that was taken was a validation or repugnancy point. It was said that as a result of the choice of English law, the parties' legitimate expectations based on the words that they use would not be met to do with the novation to another party. Answer no. What the party didn't do was say, paracete, dalico, pretty obvious here that this is a case of choice of paracete gives me choice of French law, nor did Lords, Hamlin or Leggett. So we rely on Kababi in the sense of showing that if this was a runner, it would have been run. The fact that it wasn't tells you lots. Forum. 3 headings, very briefly. What is the search for? And that is the characterization issue. What is the outcome if you characterize this claim as an anti-suit claim, which we say you should? And what is the outcome if you characterize this claim as a breach of contract claim, which my learned friend says you should? First of those, the search. CPR 6.37.3 mandates a search for the proper place to bring a claim. That is now authoritatively determined to be the same thing as the Spiliada test. We won't go back to Spiliada. In other words, the place where the case can most suitably be tried in the interests of justice, etc. That effectively involves 3 inquiries. We have the burden on these. The interrelationship between those 3 inquiries is not entirely clear, even on the latest case law. One is there a natural forum for this claim? This is all subject to the characterization issue. Secondly, is that natural forum available? It's not entirely clear what available means. It could mean available under the local jurisdictional rules, or it could mean available in a fuller sense. But let's call that availability. And then thirdly, even if it's natural and available, is there nevertheless a risk of substantial injustice in that forum? But as Lord Briggs says in Vedanta, paragraph 88, if there is a risk of substantial injustice in the natural forum, it might be said that it's not available. So I only make that as an observation, that let's not get too hung up on the 3 limbs, because they may in fact be a composite inquiry. Ultimately, and only, I have to show this court that England is the proper place to determine this claim. That begs the question, well, what is this claim? And that's in a sense why I jumped forward earlier about breaking the circuit. What English private international law does in order to wrestle with this is it looks at the thing in front of it. It looks at the claim that goes to trial. And it says, right, what is this claim about? What does it involve? So in the Supreme Court in Hawaii, which we should look at briefly, Authorities, tab 14. So this is a judgment, I believe, of the court. And it's paragraph 94. And I was going to emphasise the final sentence of paragraph 94. Identify the dispute between the parties as the matter to be tried. And then you see from the opening of paragraph 95 that that's a question of substance. They say there it is in substance a dispute, etc. So what the court always does to break that circle is it looks at substance and it applies its common sense. Now, pause there and ask what is the matter to be tried in this anti-suit claim? There is no issue of liability at all. It is not being said at any point by RCA that they haven't breached the arbitration agreement. I showed you the Russian statement of claim. It's quite clearly a breach, or it involves a breach of the arbitration agreement, seeking payment out of €500 million under the bonds. So this isn't a breach of contract claim in that sense. There's no liability issue at all. This is going to be at trial, which is the thing we tried to have on the 22nd of September, and we would like to have today, if the time permits, for you to grant this relief. It's a fight about strong reasons. What are the strong reasons for refusing the grant of this relief? Or to put it another way, what is this claim about? This claim is about whether the Russian proceedings should be stopped. It's not a claim about whether their pursuit is unlawful. It's wholly artificial, and like I say, a triumph of form over substance. For my learned friend to say this is a breach of contract claim, which is amenable to arbitration in Paris, and therefore we can have our damages award from the Paris Arbitral Tribunal in a couple of years, which we can't do anything with. We'll come on to that in a moment. If you want to, in a sense, triangulate that modern definition of the characterization issue, you can look at VTB and Nutritech, which is Authorities tab 8. Again, Supreme, I know it might be Court of Appeal, Supreme Court, this one. Paragraph 192, you look at the issues of the trial. So what the court has to do is has to look to see what the issues are to be determined by the court. And this is, on any view, an anti-suit claim. This claim is about whether the Russian proceedings should be stopped. It's as simple as that. And therefore, moving to heading 2, we can turn to the Deutsche Bank decision in the parallel bank case that I alluded to. That is in the Authorities tab 20.
The forum issue in Deutsche Bank was different from the forum issue here. In Deutsche Bank, it was the usual case of should it be the English court or a foreign court, i.e. the French court. But the judge's comparison is between the English court and a French arbitration.
Yes.
And French arbitration is, I think, the only case which is put forward by Mr. Hussain. So does Deutsche Bank have anything to say about that? It doesn't look to me as if that was an argument which was anticipated by Deutsche Bank. Of course, RCA weren't there.
No, well, this judge, in our case, erred in law by characterising the case as a breach of contract case. That's one of the ways he went wrong for him. And once you go through that characterisation gateway, that then invites a whole set of questions about, right, what can you do with that breach of contract claim? You can go to arbitration, you can get a damages award, and because English private international law says a better remedy somewhere else, or rather a better remedy in England, is not a juridical advantage, therefore that's the answer. So the gateway error, if I can use the word gateway, it's probably not the best word in this context. The threshold error the judge made, in our case, was to mischaracterise the claim. He got hung up on it being a breach of contract claim. Of course, there's no liability issue, as we know. It's an anti-suit claim. So he ran his analysis there. He got that wrong, as it happens, and that's going to be stage 3 of what I'm about to say. The Deutsche Bank, they didn't get it wrong, they got it right. They said, look, this claim, the essence of what this claim is about is stopping unlawful and vexatious foreign proceedings. It's a claim for an injunction.
The remedy sought is an injunction? What, using old-fashioned language, is the cause of action? It is a breach by the respondents of what, which you say entitles you to the injunction.
Yes. The cause of action, if you want to approach it taxonomically, the cause of action is breach of contract. It's breach of a baked-in promise not to litigate certain disputes.
It's an implied term of the main agreement.
There's a debate about whether it's simply the flip side of a promise to exclusively arbitrate, or whether it's an implied term that if you say, I will only arbitrate, it must be an implied term not to.
I can't remember. Does the bond say, I will only arbitrate, or I will arbitrate?
The English will approach to standard phrased arbitration agreements is that a clause like this is a promise, an exclusive promise to arbitrate the relevant disputes.
So the claim is for a breach of Article 12, breach of Clause 12.
It is. That's the cause of action. But I've shown you Huawei in the Supreme Court.
Yeah.
I've referred you to VTB in the Supreme Court. You don't look. This isn't a taxonomical approach. You don't pigeonhole causes of action. You look to see what this claim is about and what is going to trial. You look to see what the issues are, because that's the forum inquiry. The forum inquiry is, well, which place is the best place or the appropriate place to deal with this claim. It happens to be a breach of contract claim, but the claim is a claim about stopping foreign proceedings. It's a claim about strong reasons insofar as they exist. So we say Deutsche Bank just got that right. If you were to criticise the Court of Appeal in Deutsche Bank, they didn't hesitate. They didn't hesitate over the characterisation issue, and that may well be because my learned friend or his predecessor wasn't there. But the fact that they didn't hesitate over characterisation, in a sense, just shows they saw it as so obvious. You can pick this reasoning up in paragraph 36. And it's basically paragraphs 36 to 41 are critical. I wasn't, with the time left on the clock, going to go through it line by line. But you see they start on the third requirement. That's the forum requirements that they set up in paragraph 34. They say it is natural to regard grant of an ASI as something to do with choice of seat. They kind of head off that choice of seat point, which has come up per Lord Hoffman in West Tankers and also in the Supreme Court in Enka. It has sometimes been said, admittedly by judges of the highest authority, that the ability to grant anti-suit injunctions is part of the court's supervisory or cural jurisdiction. With the greatest respect, those judges have overspoken when they have said that, because we know from AES in the Supreme Court that the power to grant anti-suit injunctions comes from our mandatory lex fori, from section 37 of the Senior Courts Act, as it's now known, and therefore applies whenever the English court has jurisdiction in persona. It just so happens that if you choose English arbitral seat, you are taken to have submitted to the English courts. So your choice of English seat is your submission into this court, and it's your submission into the section 37 jurisdiction. But it is not the case that anti-suit power is a power of this court wearing its cural or supervisory hat. It's a mistake to see it that way, and the Court of Appeal said so in terms. They say
incidentally, sorry to interrupt, paragraph 35 reminds me that what Lord Justice Nugent says is good arguable case English law, and strictly speaking, that may be all you need for jurisdictional purposes, but presumably, if you want a final injunction, you're inviting us to finally decide.
We had this debate below, and we are not taking the interlocutory standard point. As far as we're concerned, we presented before the judge on the 22nd of September, seeking a final trial order.
Well, I thought that was the position.
And we are taking the burden on the balance of probabilities.
Yep. Okay.
But you're right to pick me up on that. I should have flagged it. So the Court of Appeal at the end of 36 deal with the intuitive at first blush point, saying, well, hold on a sec, if England isn't the court of seat, then why are you here asking for that? And then they say 37 and onwards, but I do not think that necessarily follows. They cite Vedanta, which is effectively the latest enunciation of the Spiliar test, and they quote Lord Gough, identify the forum in which the case. They then say, and 38 is very important, they recite the public policy of English law to hold parties to their bargains, and particularly to do so when that bargain is a jurisdictional one or an arbitration. That evokes something said by my Lord Justice Mayles in the Norrie case, sitting at first instance in paragraph 106 of Norrie, which is that the enforcement of arbitration agreements is even more jealously guarded by the English court because strong international policy in favour of arbitration. So
Yes, that was an English seat case then.
that was in the context of what strong reasons you would need. Yes. No, it wasn't. It was an English seat case, of course.
Yes,
of course. But the point is, the public policy is the same. The English court has set itself out as a forum that is known for enforcing arbitral bargains. And so that is part of English public policy. And of course, you see that reflected also through paragraph 39 in Angelic Grace. I won't go back. I wouldn't dare go back to what Lord Millett says, or Lord Justice Millett says in Angelic Grace. But of course, it is a principle of English law that damages are not an adequate remedy for breach of a jurisdictional promise. And the reason for that is that the damages inquiry, it doesn't matter, the damages inquiry is fraught because it runs for as long as the foreign unlawful proceedings are running for, so you can never really get your final justice on it. You will never get made good for all of the costs and the hassle of being dragged through a court that your counterparty promised you would never be dragged before. And therefore the anti-suit jurisprudence, which is a highly specialised form of injunctive relief, with it, like I say, with its own practitioner text, etc., has developed in order to protect that promise. But the reason English law protects that promise through an injunction is because damages aren't good enough. That is part of the answer to the judge's reasoning in this case. He said, well, you go off and get your damages award from the arbitration, but that is just fundamentally inconsistent with the way English law approaches arbitral promises or any jurisdictional promise. It protects them by injunction, unless you lose your right to an injunction through delay, etc.
You've alluded to Mr. Raphael's book. Does he have anything to say about grant of an anti-suit injunction in support of an arbitration in a foreign seat?
He does, by reference to a Hong Kong case. I won't say of some antiquity, but it's a while ago. But things have moved on since then. There have been two Caribbean cases originally. This is how it's gone jurisprudentially. Two Caribbean cases in which grant of foreign seat anti-suits were recognised and allowed. It was common ground between counsel before the Court of Appeal in Enka that was a permissible approach, albeit obiter, because Enka was an English seat case. That common ground was nevertheless recorded by Lord Justice Popplewell without comment. And of course, Deutsche Bank now, albeit uncontested, says that's not a problem. Deutsche Bank's been applied since by Mrs. Justice Dias, but that was also an English seat case as well. But this is, I'm not
Deutsche
going to
Bank
say
was,
this
the
is,
seat was England, wasn't it, in Deutsche Bank? The contract was English law and the seat was England.
No.
Oh, hang on.
Deutsche Bank is on all fours with this
one.
case in terms of the contractual matrix.
Right.
So
The only factual difference is that an
Oh, yes, arbitration in Paris, that's right, yeah.
Yes, and the other factual difference, as I alluded to much earlier, was the fact that there's evidence here of executable assets. Yes.
Yeah, it's arbitration in Paris in clause.
It is. It's Paris ICC, and that's the case of Commerzbank as well. There's a trio of cases. But like I say, the other two are in a sense stayed behind.
I mean, I've assumed, is this right? They're all concerned with the same project.
They are.
Yeah.
Yes, they are. They're all guarantees given by different banks in relation to the same.
For the plants which will be built in Russia by Linda.
Absolutely. I have reason to believe there may even be other claims lurking as well. And of course, Linda itself has been dragged before the Russian court, as you have seen, by RCA. But there we go. Now, moving on, it really hots up in 40 and 41. Can I just ask the court to read that and note the characterization of the claim? And so, as far as the Court of Appeal is concerned in Deutsche Bank, there's no real debate about how you characterise this claim. This is a claim to stop unlawfully commenced and pursued foreign proceedings. We can just call that an anti-suit claim or an injunction claim if we wish to. And therefore, on that characterisation, which we say is the correct starting characterisation, there is no other available forum, because it's common ground you can't get these things in France. And it's common ground that you can't convert an arbitral anti-suit into a court anti-suit in France. And as I'll come on to explain, but I've already hinted at, the notion of my client being packed off to arbitration, given its exposure to execution against a judgment which is potentially just 3 weeks away in Russia, is deeply invidious. And the way the logic works towards this, which you can see in Deutsche Bank, which I would endorse, is you start with the fact that it's English public policy to enforce arbitral bargains. You go through angelic grace, which says, as a matter of English law, damages are never an adequate remedy for breach of an arbitral bargain or an exclusive jurisdiction agreement. And then your characterisation is supplied by that. It's supplied by those features of English law. It is also supplied by the fact that in this case there's just no other issue other than the anti-suit issues that are left for determination. So this is an anti-suit claim. That is the matter to be tried. It can't be dealt with anywhere else, and England is the only place. So we adopt and endorse the reasoning of the Court of Appeal in Deutsche Bank, which, like I say, is on all fours in terms of the contractual matrix. It does represent English law. It is soundly reasoned, albeit brief, but its brevity is just how emphatic it is, and we say it's obviously right. It's 2 minutes to, and I'm going to need 5 minutes to finish for me. So,
All right.
if I may.
Yes.
Thank you, and I apologise for that. One of the things my learned friend says against this is, well, you've chosen Paris seat, and as you say, claimant, and as is agreed, French law doesn't grant anti-suit injunctions, and therefore you are taken to have agreed you can't have anti-suit injunctions. Now, we say that is a bad point for a number of reasons. It is a non sequitur, because of course the power to grant anti-suit injunctions to enforce and uphold a bargain has got nothing to do with the supervisory jurisdiction. That's the AES point. It's simply a power. It's an ancient power, it's the injunctive power, which is now enshrined in Section 37. If an English court has in personam jurisdiction over a defendant, it can grant an injunction if it's just and convenient to do so. So the fact that Paris as curial court won't do it tells you nothing about whether the English court can or should. Plus, that's hardly a forum point. It's more of a final relief point. It is also, if I may say so, a repugnant point, because what they are basically saying is by the parties choosing Paris seat, they are taken to have agreed that they cannot be held to their bargain. So the argument doesn't work like that, or at any rate it is deeply unattractive. And of course, the characterisation that my own friend adopts in order to run that particular argument is also quite a telling one. I'll give you the reference. In paragraph 85 of his skeleton argument on this point, he says that the natural place to deal with a claim for breach of an arbitration agreement is before the curial court. Now that's an odd one, because you would have thought he'd be saying it would be in arbitration, but there we are. What he's really saying that daren't say is that the natural place to deal with an injunction to stop breach of an arbitration agreement, he would say, is the curial court, but of course he can't say that, he seems to. So that's the answer to that. And then we get to, well, what if it's the alternative characterisation, this is the heading 3 of 3. If this is a breach of contract claim, and with the greatest respect I would say that is a very archaic and artificial way of characterising this claim, we say even if France is technically an available forum for arbitration, it cannot deliver substantial justice. And all I have to show on this is that there is a real risk of substantial injustice. And the context for this is all that stuff I showed you at the very outset, the Russian court's power to injunct an arbitral process, the Russian court's season of jurisdiction, which allows RCA as putative arbitral respondent to set up a res judicata to challenge arbitral jurisdiction in the arbitration, the Russian court's imminent and likely entering of substantive judgment against my clients, which again would allow RCA as putative arbitral respondent to set up another res judicata in the arbitration. You can see what they're going to do, and indeed would set up the ultimate defence to enforcement of any award, even assuming the Russian court were to honour its obligations under the New York Convention Article 5, which it won't, because it will have already decided there is no arbitration rights here. My learned friend will have the purest defence under Russian law to enforcement, which will already have a judgment to the contrary effect from the Russian court. So that is not a realistic or indeed just outcome if you leave my client without any remedy or protection to its chances in arbitration. And that's assuming an arbitration can even get going, because of course the anti-arbitration injunction risk is ever present. If you drop the protection now, they will run to the Russian court to get either a quia timit anti-arbitration injunction, because they know an arbitration is coming, or the day after we file for arbitration in Paris, they'll go to the Russian court and get an anti-arbitration injunction for an arbitration on foot. That's what they will do, as well as trying to destroy, through all the torpedoes they have in their armoury, provided by Russian law and res judicata, that very arbitral process. And let's say they don't achieve that. What do we come away with? A damages award for a reasonable amount of our Russian legal costs to set against a €500 million judgment entered against my client by the Russian court, all because this court felt that it shouldn't stop that which is unlawful. We say that would be an unjust and regrettable outcome to this appeal, and therefore we ask this court to allow the appeal on jurisdiction and to go forward and determine, which I would say would take about 10 minutes. You may not have faith in my estimate. Let's call it 15 minutes. The strong reasons, objections to this final relief are around about a 15-minute debate. And we would like to have that today, or as part of this court's order, as soon as possible if we could, please. Unless I can assist the court further, I apologise.
No, that's all right.
I'll just say this, that if you want it today, I have no idea whether that will be viable or not, but you'd better produce a draft of exactly what it is that you want us to do. The draft order in the bundle would need at any rate some updating and query whether all the recitals, etc., are really as they would need to be.
We will look at that. One thing you will see that we have put in is an undertaking not to rely on the English court's grant of final anti-suit relief as being preclusive of any argument that RCA would want to take on matters around validity and scope, because we felt that that was appropriate if the English court was to grant final relief. In other words, they remain free to argue in arbitration whatever they want to argue.
Well, I just raised it. We haven't heard Mr. Hussain yet, and,
Yeah.
who knows where it goes. But if it's even a possibility that you're asking us to do something today, that's an essential piece of information we would need to have.
It is. Well, I appreciate that. We'll give that some thought. There is some time, because the next hearing in Russia is the 14th of February, so there is some time, but it doesn't need another day in the commercial court, which my learned friend says.
Where is the current draft order?
That's the main appeal bundle, tab 13.
Right, thank you. 2 o'clock.